All right, I hope you had a few minutes to enjoy the resources on the third floor, our 3D printer and Mike from IQ, as well as Ray Brewer from Xerox and the Chester Carlson Archives. Those things will be going on all day, so please feel free to come and go as you would like. Those programs, again, will be going on. Mike will be on the third floor. Ray will be here. But right now, what I'd like to do is talk to you about our next presenter, who is Mindy Bickel. She began her career at the United States Patent and Trademark Office in 1989, where she became a supervisory patent examiner in 1995. She previously managed the Patents Ombudsman Program, which serves as a resource for patent applicants, agents, and attorneys, and has served as Chief of Staff to the Commissioner for Patents. She has received numerous awards throughout her career and was appointed Associate Commissioner for Innovation Development in December of 2015. This office ensures that independent inventors, small businesses, entrepreneurs, and underserved populations better understand, secure, and use intellectual property. Please join me in welcoming Mindy Bickel.
Well, thank you so much for welcoming me to beautiful, sunny Rochester. Where do you guys keep the sun? I was telling Deb that I flew in yesterday. I had to speak last night in Fredonia, and my office made arrangements for whatever reason to fly me in on the very first flight yesterday, so I got up at 3:45. I thought, okay, no problem. I'll get on the plane, I'll sleep, I'll get off the plane, maybe I'll go see Niagara Falls. Well, I don't feel like I needed to actually go to the falls. I think the falls kind of came to me, so here we are. Before we start, thank you, Kate, for the introduction, and you know a little bit about me. I'm interested in knowing just a little bit about you. Any patent holders? Congratulations. Anyone who has filed but is still working through the process? Great. Patent attorneys? Trademark attorneys? Okay. Anybody thinking about filing a patent application but just haven't decided? Okay, great. And everybody else is just here because where else would you be on a Friday morning but the library? Okay, so I have until 11:30. I have a very aggressive agenda, as you can see on the screen. Reasons for that, but the biggest reason is because I want to make sure you get the information that you are interested in getting while you're sitting here with me. Also, if anyone is a stellar participant in conversation, I have one paper copy of my slides, and you can be the lucky winner of that paper copy if you want them. I always travel with one just in case technology fails. This slide is probably the most important slide in my slide deck, and I am going to skip right through it because I have found from experience that if I stay on this slide, I never get past it. So we could probably talk for 45 minutes just on this slide and the questions that you might have about it. But I tell you that because when you look at the recording afterwards, or Deb, you can certainly make copies or electronic copies available to whoever wants my slides. This is definitely a good reference tool. So it compares the different types of intellectual property, what's covered, how long the protection lasts, and just the kind of handy-dandy cheat sheet, so to speak. This slide we use because we want to make sure people are really thinking about their inventions or their products in a very holistic way, and that you're not limiting your thoughts about intellectual property protection to just one type. So you want to think about it as an umbrella. And if you leave any holes in the umbrella, especially on a day like today, what happens? You get wet. So you want to really look at what you have and see how many different ways you can protect that invention, and make a decision for yourself, a strategic decision about whether you want to pursue that protection. Now, we all know that it does cost some money to work through the patent process, less money to work through the trademark process, but still some, even less money to register with the Copyright Office, but still some. Trade secrets you handle on your own, so you would probably might want to seek the services of a professional, still some money there. And of course, there's more than one type of patent. So there's 3 types of patents: utility patents, design patents, and sort of a very little known area called plant patents for living plants that can be asexually reproduced. I'm not going to get into that today unless there is somebody in the room who has an invention in that realm. So you want to just be thinking about all those different types. We give an example. This is not a U.S. Patent and Trademark Office endorsement of the iPhone. It just is a great example of one item protected in many different ways. And this sort of also hit home for me when I first started doing university outreach for the Patent and Trademark Office in 2007. And I was somewhere in New York. I can't tell you where it was, but not in New York City, some Schenectady, or I'm not sure where, but somewhere in New York. And I was in the fitness center, and I looked over at the weight machine, and it had 2 utility patent numbers, a design patent number, and a trademark symbol by the name of the machine. And I thought, that's a great example of what we're trying to say. Protect in as many ways as you can. So I think Katie kind of breezed through different types of IP, and I'm not going to be able to go, of course, into depth on any different type, but most people are familiar with what a trademark looks like or is, or that companies use them. So there's several examples of trademarks. Trademarks are really what gives the consuming public certainty of the source of a good or a service. And there's reasons why companies would want that, and there's certainly reasons why consumers would want to know the source of a good or service. For a company, of course, it could create very strong brand loyalty, right? There's Starbucks up there, and again, this is not a PTO endorsement. I do happen to like Starbucks. My husband likes Peet's coffee. It's just how it is. They're probably both just really coffee, but people become very brand loyal. Coca-Cola and Pepsi, right? People don't want the other one. They want the one they want. Now, I don't really drink soda anymore, so to me they're sort of just, brown carbonated sugary beverages. But if you are a Coca-Cola drinker, you would think that what I just said is heresy, and it's completely different than Pepsi. The interesting thing about a trademark, and I think it said it on that first cheat sheet slide, is that they can last indefinitely as long as you don't allow them to become generic as the trademark holder. So, anybody know what generic might mean in this context? Guesses? I feel like I heard something. Yes? Xerox is what?
Well, you go to Xerox something, but it's actually to photocopy. People start using Xerox as synonymous with photocopy.
And Xerox fights that. So I think in the 90s, if I remember correctly, Xerox took out some full-page ads in the New York Times and other newspapers saying, unless you are using a Xerox copier, you are not Xeroxing. You might be HPing or Canoning or something like that, but you are not Xeroxing. And they take it really seriously because if they don't, they could go the way of Escalator. Did you know that Escalator was somebody's trademark way back? The generic was moving stairs. And Escalator did not vigilantly take care that people weren't using Escalator generically, and so they lost the ability to renew. Trademarks are renewed every 10 years.
Well, I don't understand. I see what you said about Xerox putting on that, but there was a court case and they could bring in hundreds of people saying we use Xerox generically. How can they argue against that?
Right. So I'm not going to go too far into depth on the particular of how something would become generic. If you are interested in that, if you have a trademark and you have a concern about that, you might want to consult a trademark professional and find out what steps you need to take in order to show that you have diligently thought that. I mean, here's the reality. People do say Xerox and walk up to a Canon copier, right? There might be a photocopier somewhere in this library and somebody might misuse the word and say, I want to Canon this paper, or Hewlett-Packard this paper, or Xerox this paper, and walk up to whatever kind of photocopier it is. Companies obviously can't police every single use, but what they do is they look to take steps that can show that they are being diligent. And an example of that is, I believe Coca-Cola, Pepsi might also, they have mystery shoppers or eaters that go into restaurants that do not sell Coke products, Coke drinks. And the person will wait for the server to come over. The server will say, can I get you something to drink? The person will say, I'd like a Coke. And if that restaurant only serves Pepsi, and the server doesn't say, we only serve Pepsi products, is that okay with you? But instead brings the person a Pepsi when the person asks for a Coke, then they will take some action to let the restaurant know that they have improperly used their trademark. So there are things that you do need to pay attention to. I will say, this is a good point to say, so we issue patents and we register trademarks. We do not get involved in enforcement. So enforcement of intellectual property happens for patents and trademarks. It happens outside of the Patent and Trademark Office. For copyrights, it happens outside the Library of Congress, which Library of Congress administers the law with respect to copyrights. And trade secrets, there's no federal agency that administers the law about trade secrets. That happens through your own actions with contracts and that sort of thing. And enforcement in all cases happens outside of the agencies. It happens through court proceedings. So we're not involved in those. And one more note about trademarks is that a trademark can be a word or symbol, as I show on the screen. It can be a sound. So something like if you ever watch morning television or NBC, the NBC chimes, if you know what I mean, or that when you first boot up a personal computer and you hear that sound that lets you know Intel is inside, right? It can be a fragrance. I've often wondered how they determine whether it's sufficiently different as a fragrance. Obviously, I'm not the tester, so they have rules over there. I've never asked the question. And they can be colors. So many options. Colors, a great example. If you see a brown truck, you don't need to see the letters UPS on it. If you see that kind of brown truck, and I think it's got a yellow stripe or something, you don't necessarily need to be close enough to read UPS. You kind of just know it's UPS, especially if the delivery person steps out in a brown uniform. So those can be very strong identifiers. These are relevant. I was on a detail in New York City for a couple of years, and so a lot of my trademark examples are from New York, but hey, I'm in New York, so it works here too. Just other examples of trademarks. And again, I mentioned these are the reasons why you might be interested in getting a trademark, because it really does create that brand recognition. And in some ways, again, as the trademark holder, you want people really using your product and thinking of your product, and then you need people to only name your product when they're using your product, right? So, think about Google. Google probably Google, of course, wants people to use Google as their search engine and have people really think about that when they're starting to do a search. But they have to be careful then, of course, that people aren't just saying, I'm going to Google, and then they go Yahoo or Bing or whatever it is they do. Okay, so that's trademarks. Questions about trademarks before we go into trade secrets?
A word in...
Can you speak a little louder? I'm sorry, I can't hear you.
I have a word, my company name, my product name, which is my logo, and then I got a TM after it. Does that prevent anybody else from a registered trademark on my logo word?
So, yeah, it's probably a little bit more complicated of a question than I'm going to answer. So you don't have to register your trademark before you start using it. You could start using it. Now, you in all cases with patents and trademarks, before you go down a path using a company name or some kind of trademark, we would suggest that you consider doing a search on our website to make sure that nobody else has registered anything that's similar. You might want to also just do a search more widely to make sure nobody is using anything that's similar that could prevent you from being able to register your trademark ultimately. And of course, you don't want to have any confusion between your company and another company. And we suggest you think about the same things with regard to a patent. If you're working on an invention, you can search on our website, and you have this great resource that you're sitting in, Patent and Trademark Resource Center. I think the PTRC librarians are unsung heroes. They can help you understand how to use the search tools on our website so that you can do some searching on your own without having to necessarily pay money to pursue something that you might never want to have pursued anyway because it's already known. So you can come here and they can help you learn how to use our search tools to your best advantage and take a look at that. You had a question? In the plaid shirt. Mm-hmm.
Oh.
You.
Do you get the instances where people just file trademark after trademark over somebody's in the bottom use that?
I don't know the answer to that. So I do not know the answer to that question. Yeah.
Is that something, if you got 100 trademarks and didn't use them, you just still got another if you're not using it?
Well, trademarks are a little bit different in that you have to, when you renew them every 10 years, you have to show that you are using them in commerce. And before it's registered, I believe, so I'm not on the patent side, I'm on the patent side, I'm not on the trademark side, so I'm not really a trademark expert, but I do have a trademark. And when you file your application, you either have to show that you're using it in commerce then, and of course for us, for it to be a federal matter, it has to be interstate, not just within the state of New York or whatever state you're in. So you have to show you're using it in commerce, and then during your first 10-year period between years 5 and 6, you have to show that you're using it in commerce. And then when you go to renew it, you have to show that you're using it in commerce, or it will lapse. You had a question right next to him?
Yeah, well, the logo is sort of a picture, so when you're doing a search, it's sort of a picture name.
So I'm going to let you go ahead and ask one of the librarians how you could best search for that kind of thing. Okay? All right, so trade secrets. I'm going to go to him, and then I'll come to you. And I'm going to say, just being mindful of the time, it's 11:09, and we have a lot of information to get through, so I don't want to get too stuck on trademarks. Mm-hmm.
So the main purpose of, I'm more kind of related to that, the risk of not enforcing a trademark is pretty much your market and your perception of people. It doesn't have really anything to do with ownership. Like you don't really lose, I don't know, like your name, but it's more about like the perception of that you create with a trademark.
So I'm not quite sure I understand the question that you're asking me.
So what is the risk of not enforcing a trademark?
What's the risk of not enforcing a trademark? It's simply that other people could use that trademark for a similar product. I showed the iPhone. Imagine if Apple did not enforce the iPhone trademark, then any phone manufacturer could call their phone an iPhone. And if the product is a very desirable product, I'm not judging iPhone, but a lot of people like it and want it. And so if there's a big market for that product and other people can call their product the same name you call your product, you might lose some of your market share. But these are questions that you would need to answer for your business strategy. And Katie talked about the patent pro bono program. We do not recommend that you go it alone in patents. And really, I believe that the trademark folks would say the same thing, that we can tell you the nuts and bolts of how to work through the process. We can tell you how to search. We can tell you what a claim should look like. We can tell you what needs to be included in the application, but we can't advise you on what should be in your application or what your trademark should be to best suit your business needs. And so the people who do that, those are patent attorneys and trademark attorneys. They can advise you. They're licensed to give you legal advice, and that's what they can do with you. They can sit down and talk to you about your business strategy. What would help you best move your business to where you want it to be? We can't do that. So remember, I said what we do is administer the law with respect to patents on our side of the house and trademarks on the other side. And we will look at your application and see whether it complies with the statutes as set forth by Congress, with the rules of practice that have been set forth within our office, by formal matters, all of those things. And we will tell you if it doesn't comply. We might make suggestions about changes you could make so that it would comply, but we can't tell you whether those changes would be good for your business or not. An attorney that you hire can tell you that. Okay, so, and I think in the back you had a question?
Yeah, what happens if you give permission?
Little bit louder.
Okay, what happens if you have permission from someone else to use their logo? Do you use that in your logo and trademark it? If you have prior permission?
If somebody gives you permission to use something of theirs, I can't see any reason why you couldn't use it. Again, that might be a conversation you want to have with a professional that you hire to work for you to advise you on whether that would be a good thing for you or not. Okay, so I'm going to go quickly through trade secrets because it's 11:14, and again, just trying to be mindful of time. Trade secrets have a big advantage over patents in that they can last forever. So I mentioned Coca-Cola before. KFC's 11 herbs and spices. Somebody told me that they published that recently on the internet, that KFC published it. I'm not sure whether that's true, but that was also a well-known trade secret. Trade secrets are, again, something that you handle yourselves. There's no agency that you go to say, hey, I want to register my trade secret. You handle it. There are steps that you need to take to show that you have diligently worked to prevent disclosure, as the slide says. Again, that might be a place where you want to talk with an intellectual property professional and get some assistance in dealing with the issues surrounding that. If it's true, and again, I don't know whether it's true, but if KFC did publish those 11 herbs and spices and what the ratios are and all that sort of thing, well, then they've lost their trade secret, right? Because they've disclosed it. A cautionary note, if you have something that's easily reverse engineered, is that a good thing or maybe not a smart thing to try to protect via trade secret? It's not a good idea. You can certainly try, but imagine if it's easily reverse engineered. If we could easily discover the formula for Coca-Cola and we could all go home tonight and cook it up in our kitchen, Coca-Cola would no longer be needed. They wouldn't have a product anyone wanted to buy because we could all make it ourselves. So if it's something, Coca-Cola obviously is not that easily reverse engineered because it's been a secret for a very long time. But if you have something, if you come up with something and it is easily reverse engineered, probably not a good idea. And the thing to remember too is somebody could come up with that through the same thing that you did through independent development. They are allowed to do that. And there's a lot of areas where there is multiple group activity, a lot of people looking at the same thing. trying to solve problems, that sort of thing. So those are things to keep in mind. But if you have something that's not easily reverse engineered and you take those adequate steps, you could actually protect your trade secret for far longer than you would be able to have your patent term. Any quick questions about trade secrets before we move into patents? We should put patents first because it takes longer and it's always at the end. Things to remember about patents. So first of all, patents are specifically mentioned in the Constitution, Article 1, Section 8, Clause 8. I'm not sure whether I have it on a slide here, but I do like to mention that. So people sometimes say to us, why don't patents last forever like trade secrets? I want my patent to last forever. I probably don't want anybody else's patent to last forever, but I want my patent to last forever. Why can't they? Well, because the Constitution says they can't. The Constitution says that Congress has the authority to promote the progress of science and the useful arts, and I'm not going to try to go farther from memory, but by providing to inventors an exclusive right for a limited time. So limited term and exclusive right are the really important things, as well as, remember what I said at the beginning, the preamble, to promote the progress of science and the useful arts. So sometimes people complain about the patent system and, you know, somebody has a patent, now the rest of us can't do it. Well, it does promote the progress of science and the useful arts. Imagine if everything were held as a trade secret that could be held as a trade secret. It would be really hard for research to move forward and for science to progress. The quid pro quo, any Latin scholars in here? I usually have one. No Latin scholars? Okay, quid pro quo is an exchange, this for that. So there is a quid pro quo in the patent system, and that is that the inventor completely discloses to the public through us, so we act at the Patent and Trademark Office on behalf of you all. That's what we do. We're not some separate, monstrous entity all on our own. You disclose it, and we make that available to the public, and then the public, all of us, at the end of the patent term, we can freely practice that invention. And we have a lot of information about it, and we can use that information that's disclosed to either just practice that invention, or maybe it will help us solve a problem with our invention, or maybe we can think of a way to improve that invention. Those things wouldn't be possible if everything were held a trade secret that could be held a trade secret. So just something to maybe have you think about if you find yourselves in a place where you're saying, that darn patent system, that patent is preventing me from doing what I want to do. Well, remember, there's an exchange, and ultimately we do get to do what we want. The right is an exclusive right. So you, as the patent holder, the inventor, have the right to exclude others. How many people think that a patent gives you the right to practice your invention? Anybody? It's okay if you say yes, because a lot of people think that. Thank you for admitting that you think that, because I'm sure there's others in here that think that too. Well, it doesn't. It gives you the right to exclude others from practicing your invention. And specifically, as it says here, from making, using, selling, offering for sale, or importing your invention. There's a good reason for that as well. Why aren't you given the right to practice your invention? Well, let's say you, in the tan jacket with the red shirt, you invented a pencil. Bravo. Awesome. We love that invention. Everybody uses it. And you, in the black and white, ma'am, you invented an eraser. We love that too, because every time we write down something, 5 times out of 10 we need to erase it. And we couldn't before. Thank you. Well, we have to carry your eraser around separately from your pencil, because that's how you invented them. Ma'am, in the purple scarf, you came up with the idea to put the two together. Bravo to you too. We love that. Now we have a pencil with an eraser on the end. We don't have to worry about carrying around your eraser, carrying around your pencil. But if we, and you all have patents, and if we gave you the right to make, use, and sell your pencil with the eraser on the end, do you think that would be fair to our pencil inventor patent holder and our eraser inventor patent holder? No. because you'd be infringing on their patents. So there's, of course, ways that people take care of that. People, tend to want to follow the money if they can and sort of think, hey, you know what? You two might just say, give me 5 cents from each pencil that you sell, and we're all happy and good to go. And you would handle that, again, as a separate matter. You would, might have a patent professional who would negotiate that for you. But that's the reason that it's an exclusive right. We don't want to give you the right to infringe on anybody else's patent. Another important point, where do you think a United States patent is valid? In the United States. Who said that? Thank you. And its territories. We don't want to leave out the territories. It's not a worldwide patent. There are no worldwide patents. So anywhere that you think you might have a market, you might want to talk, again, to a patent professional and say, I think this might be something that has a market in another country, and I therefore want to think about having patent protection in that other country, or I'm going to manufacture in another country, excuse me, and I want to make sure that they don't make 1 for me and 2 for them and sell them in their country. So those are discussions that you want to have, and you want to have them early on, because there are some countries where you lose your patent rights if you disclose your invention publicly before you file in those countries. In this country, we have a 1-year grace period, but in some other countries, that's not the case. Of course, we think that reasons for getting a patent are self-evident. Of course, everyone thinks it would be wise to get a patent. Anyone who's ever watched Shark Tank? Anybody ever watched Shark Tank? So, frequently there is a question, have you filed a patent application? Do you have a patent already? So investors are interested in whether you have exclusive rights to your invention, because, again, if everybody's free to make that pencil with the eraser on the end, we don't really want to invest in your company, because there's 40,000 companies making the same pencil with the eraser on the end. But if you have the exclusive right, and we could sue anybody who is making those pencils without our authorization, we stand to make more money, and an investor, of course, is interested in that. You can also use the fact that you received a patent from the federal government to promote the unique aspects of your product. Hey, I can show you this is a novel invention. This is a non-obvious, which is a weird word that I think I might have time to get into later, but your invention has to be non-obvious in order to be patentable, and it has to work. So you have this stamp of, it's sort of like the Good Housekeeping seal of approval, but you have it from the federal government, which might be marketable as well. And I had a question last night, actually, from a presentation I did. Somebody said, well, can I just buy their patents? Well, you can if they're willing to sell them to you. You can buy them, you can sell them, you can inherit them, you can leave patent rights in a will to somebody. You can license them, sort of rent them. You can deal with them as you would other types of property. I mentioned in that first handy dandy slide, there are design patents as well as utility patents. Now, what I just spoke about, those are typically utility patents. There's also design patents, which can be very important. I was speaking to an inventor a couple years ago, and he was talking to me about sort of the inner workings of the utility aspects of his invention, and then offhandedly mentioned that the case that it was in was important. How that case looked and existed in 3D space, I guess we could say, was important. And I asked him if he had considered a design patent to protect those features, and he didn't know what a design patent was. So we talked about it, and I raised that because you might want to think about that too. There's how it works, but then kind of the ornamental design, the way it exists in three-dimensional space, independent of its function. So if you describe it If you describe, this bottle, for example, if you describe it as, it's got this indentation, I guess we could call it, that makes it easier to hold. Am I talking about function or just how it looks? I'm talking about function. It makes it easier to hold. But if I simply describe it as it has this indentation, it's got these, whatever, I don't even know what you call all these things. I should find out before I use this. I always use it as an example. I don't know what you call them. But if you just describe how it exists, how it looks, you are talking about a design patent. And you could protect this both ways. You could file an application because that makes it easier to hold. And you could file an application because it's a unique design. And if you think about something like the glass Coca-Cola bottle, so you don't necessarily, again, need to see the writing on it to know that that's a Coke bottle. Of course, that's not so common anymore. And some of you might not even know that we used to use glass bottles, but they were a very distinctive shape, and you would probably know if you had ever seen it. So think about both of them. Design patent has a different term than a utility patent. Utility patents have a term of 20 years from the date you file the application. So it is important that from both our perspectives that prosecution go as smoothly as possible to get the application out as quickly as possible so that your term is as long as possible. Design patents have a term of 14 years from the date of issue. And now I'm going to start to go more quickly through because we're almost out of time. So some people think, I don't need a patent. I'll just publish it and I'll prevent other people from getting a patent. Well, it might already be patented. If you don't have a patent claim and you don't have a patent, you don't have any way to stop other people from making, using, selling. And if somebody else has patented it or has a patent in process, you might be excluded. And then people get frustrated also a little bit and say, well, if somebody else is just going to, counterfeit my invention or steal it, what's the point? Well, you have no recourse if you don't patent it. And you do have recourse if you do. It can be difficult, it can be expensive to enforce, but it is the only avenue open to you. And again, this is where talking with an IP professional can be really helpful and useful. I kind of mentioned this, but I'm going to skip through it. Patent claims, writing patent claims, it's an art form. There's no real formula to tell you this is how you sit down and write it. And again, might be a place to talk to a patent professional. They can help you with that. This triangle is just meant to show if you get too specific, it's really easy for you to get a patent on it, on your claimed invention. If you're really specific, it'd probably be hard for the patent examiner to find any prior references that would render that unpatentable. But it might not be valuable to you and your company. It might not be what you need in order to move your company ahead. If you're too general, it is pretty unlikely that you will get that patent claim allowed by the patent examiner because it likely could cover at least partly information that's in a prior reference. Somewhere in the middle is a sweet spot, and there's typically a lot of back and forth with the patent examiner to get to that point. I'm going to skip over that. We do actually have a patent examiner in the room. I always like to say we have patent examiners that live in 48 of the 50 states, and they might be next to you in the grocery store and you wouldn't know it. They're normal people. People always think, what's a patent examiner like? You probably wouldn't be able to pick out the patent examiner in the room, but there is one here. And what the patent examiner does is, as I said before, they look at your application and they make sure it complies with the statutes and the rules and the formal matters, and they give you a written opinion about that. And you have an opportunity then to come back in with information where you've kind of tried to work through what the examiner told you made your application unpatentable. Because the statutes say you are entitled to a patent unless it is not novel, or it is obvious, or it lacks utility, or it's not clear. Ultimately, where you want to get to is that circle on the right, the notice of allowance, and the patent examiner will work back and forth with you to help you get there. Okay, reminder, we are a first inventor to file system. That changed with the law that was passed and signed on September 16th, 2011. And I believe the first inventor to file aspect took effect March 16th, 2013, I believe, give or take. So you really want to, be careful now. The race to the patent office is sort of an important thing in a way that it wasn't before that change. Getting a provisional application filed can really be helpful. It locks in your filing date. Again, the race to the patent office is a little bit more imperative now. You do want to be the first one in. Provisional applications for what we call micro entities, people whose income is below a certain level, who have fewer than a certain number of applications or been named on a certain number of applications, certain requirements that are on our website. You can file for as low as $65 to get your provisional application filed. Heard about pro bono? Get help. We also, so my office, I don't know if I have a slide on this, but I'm going to hope I do. So we have a lot of resources in the office. This is a great one. Anybody hear about the IP awareness assessment tool? I'm going to try to wrap up by 25 up because I know I'm running a little bit over. Anybody hear about the IP awareness assessment tool? It's on our website. The slide sort of tells you how to get there. The quickest way I know is to type it into the search box on the front page of uspto.gov. It is a self-survey. You can take the pre-assessment or the full assessment. You answer questions based on what your idea is or what your business is, and at the end of answering those questions, the full assessment takes about 30 to 40 minutes. You will get something that says you might want to consider trademarks and trade secrets based on your answers, or you might want to consider a patent and a copyright based on your answers. And then it will give you information about where else on our website you can find information about those things. So if you're not sure what you've got or how you could best protect it, that might be a really great starting place. Tons of resources. We have in my office, Office of Innovation Development, we have the Pro Se Assistance Program. Pro se is how we refer to applicants who are not represented by an attorney or an agent. You are going through the process alone. Now you may change your mind. And my office focuses for pro se assistance on people who have not yet filed their application. So you're thinking about it, you may actually have something written down that you want to file, but you haven't yet done it. You can change your mind later. You can. Attorneys, I think I have heard say, we prefer to get involved from the get-go to make sure you haven't done anything that is difficult to undo or redo. But that is your choice. We don't tell you how to go. But so you can change your mind, but you can come to us. You can walk into our office, actually, if you're ever in Alexandria, Virginia. You can call us, you can email us, and we will spend as much time as we need with you. Typically, if it's more than just a quick answer, we get off the email string and try to do it by phone or in person. We've had folks from my team sit down for 4 hours, and guess how much it costs to meet with one of our people? Guess. Zero. How often do you hear that from the government? It doesn't cost anything. It's free. It's a free service, and we're really proud of it. They do. My team does an incredible job. The examiner who is here is from what we call our Pro Se Examining Unit. So those are folks who have already filed. They have filed an application. They don't have an attorney that they're working with. And that team is also amazing. They get extra time to spend with the inventors because if you're an attorney, of course, you're pretty familiar with the process. You do it all the time, so you know how to do it. Folks who haven't gone through the process and are on their own, not so skilled at it. And so our examiners spend extra time, and they, in fact, help us with our walk-ins and phone calls. Katie talked about pro bono. I just mentioned the Pro Se Assistance Program. I'm going to skip over that. If anybody has a invention that they need to manufacture, the ACE tool stands for Assess Costs Everywhere, also a great tool. It resides on the Department of Commerce website. We are an agency of the Department of Commerce. And as you can see, there's sort of icons on this page that you can click. It will help you understand labor costs in other countries. So they've gathered statistics from a lot of different commerce agencies and give you access to that so you can make a true cost comparison. People get afraid if they ever get a letter saying, cease and desist, you're infringing on our patent, and pay me, X thousand dollars, or I'm taking you to court. Take a deep breath. Check out our litigation toolkit and resources we have there that you can read up on. Again, another place where you might want to contact an IP professional to assist you. These slides are good. I'm going to let you go through the next 2 slides when you get the slides yourselves, because those are 5 great steps to getting started. We have regional offices. You all are not in a region. You all are in part of the territory that is simply covered by headquarters. I think that's great too. And there we go. Thank you. So I'm a little bit over time. I apologize for that. A lot of information I wanted to get across. Anybody want the paper copy? Oh, you all have paper copies. You don't need it. I'm going to leave that here. Thank you guys so much.